Mr. Brennan to explain his vote.
Thank you, Mr. Speaker. To explain my vote, I want to commend Mr. Dinowitz for this legislation and just reference the fact that this is really related to an action taken by the legislature involving a submission by the governor to us a number of years ago to abolish the State Consumer Protection Board, which was a mistake, but which was a casualty of the on-time budget process in which we make these decisions that relate to doing the budget on time, regardless of the merit of every single individual thing, because of these demands by the governor. So this office that was set up in the Secretary of State's office, as our colleague on the other side pointed out, has certain defects and ought to be folded into this piece of legislation. And I hope that Mr. Dinowitz will consider that in the future so that we can effectively restore an independent body in relation to protecting consumers in the utility industry. So with that, I will.
Mr. Brennan in the affirmative. Are there any other votes? Announce the results.
Ayes 88, noes 24.
The bill is passed.
Assembly 290, calendar number 468, Ms. Weinstein, an act to amend the Domestic Relations Law and the Family Court Act.
An explanation is requested, Ms. Weinstein.
Yes, thank you. Well, presently, as many people know, in New York State, courts can direct a mental health evaluation of parties and their children by a court-appointed forensic evaluator in custody visitation cases to aid the court in making decisions, and those reports are referred to as forensic reports. And under case law and practice, which varies across the state, the access to those forensic reports and pretrial disclosure of forensic evaluator files, including the underlying data, is sometimes significantly limited, though in other cases they're widely distributed, resulting in very different judicial determinations regarding the access to those documents. And the limitations on access can raise some due process concerns about the inability or the ability of parents to adequately and effectively challenge the reports in helping to shape their child's future. So what this proposal does is it gives the litigants, their counsel, if any, and the attorney for the child in child custody visitation cases the right to obtain a copy of the forensic report and the underlying data. And what's very important is that at each step, the court has the ability to issue a protective order limiting or conditioning access to the forensic report or the evaluator's file. And in addition, the court has the authority to hold violators of the court order directing limitations or conditions in contempt of court. So that's the protection for the documents being distributed inappropriately.
Mr. McKevitt.
Yes, will the sponsor yield for a few questions, please?
Will you yield, Ms. Weinstein?
Yes, happy
Sponsor
to.
yields.
And I think just to follow on what you just mentioned before, I think the real reason why you want to make sure that there be protective orders and why this bill is necessary is the fact that within these reports by the court evaluators can be very sensitive information dealing with the child, and that if this information is disclosed or is violated, there can be very serious mental anguish and very serious harm come to the child. So that's really the necessity for this bill, correct?
Yes, and that's why there's very strong direction and ability for the court to limit, despite our granting access to the parties, the strong ability of the court to limit access based on prior behavior, based on just, as you say, the potential harm for that information being made public in some instances.
Right. I guess one of the reasons, too, there's such a need for the concern, the protective order, is that particularly in this day of the internet and the media, it may be able for someone to go and, scan in the report or take photographs of it and disseminate it, and again, can cause harm to the child, which may be irreparable. It may not be able to be easily fixed at all if this information is leaked out to school or friends or something along those lines. And again, the child may be harmed for life, correct?
Correct, and that's why there's also contempt. A judge can impose provisions of contempt for violating the requirement of confidentiality.
Right. And one thing I just want to ask about the language of the bill, and you certainly do provide that the court to issue a protective order saying that you shall not violate it and therefore give this information out. But what's interesting is when you look at page 2 to the bill and look at lines 15 through 21, it states that, if there's willful failure to comply with the court order, the person shall be in contempt of court. But then it says, and the person may be punishable as provided under section. And then when you look at line 20, it talks about the fact that if there's a willful failure to comply with the court order, the person shall be in contempt of court, and there may include punishment of fine or punishment or both. So I'm just wondering if a person willfully saying, you know what, Judge, you gave me an order saying don't disseminate information, I'm going to do it anyway due to the context of this proceeding. But then it says the court may punish a person, and I'm just wondering why the language doesn't say shall punish the person.
Again, it's to give discretion to the court. The violation of the protective order in and of itself, as you read the bill correctly, is contempt. It's
Right.
then the type of punishment to impose, whether it's a fine, whether it's a withdrawal of access, or just a verbal warning from the judge, is then up to the judge to decide what type of punishment, if any, should accompany the contempt.
I suppose that's some of the concern, the fact that, yes, a person is in contempt, but the judge may say, well, don't do something like this again, or something along those lines. And I think there's a concern that maybe those interests of the child are not being protected unless there's going to be a definite consequences along those lines. And again, the bill may not just say shall be fine or punishment, but maybe at least say there shall be some sanction, something going against the party for willfully violating a court order.
I guess that it depends on the extent of the violation. Maybe something that's really has no potential negative impact on any of the parties, or as you say, the child, so that you just want to have that flexibility of the full range of penalties for contempt available to the court.
What's interesting about this bill, and some things occur with this bill I've never quite seen before, the New York State Bar Association has weighed in with the memorandum on this bill. The New York City Bar Association has also weighed in with a memorandum on this bill. And they come to, the New York State Bar supports the bill, the New York City Bar opposes the bill, but they do so among almost the same identical reasons. And again, I've never quite seen two associations come to different conclusions but the same reasoning on both. Lawyers can do that. It's quite amazing what they can do sometimes.
Well, sometimes I do say we have 21 members of the 21 attorneys on the Judiciary Committee, and we end up with 22 opinions.
Yeah.
So, some people can look at the same set of facts and come to different conclusions. I think that some of the concerns that have been raised have to do with both whatever the practice has been in the local jurisdiction, and sometimes change. People look at it whether they would have, depending who they represent, whether it would give them an advantage or potential disadvantage. But what we're trying to do is to make sure that when you have an issue about custody and visitation, that the parties, the parents, really have all the facts available to them, and that they're able to see the information that the court gets to see and be able to respond in case there's something factually inaccurate in those documents.
I agree, and certainly I agree with you 100% that all the parties should have access to this reports to see what's being contemplated here. The parties should have at least be able to see what the judge sees as far as concerned, and I'm in complete agreement. In that part of the bill, I'm very much in agreement with the intent of it. But I think with both the State Bar and the City Bar both say is particularly, I think, in the instance where you have a pro se litigant, one who does not have an attorney, I think the way I'm reading their memorandum is they would prefer to see some sort of mechanism by saying to the non-represented litigant to, if they're going to look at the report, let them look at it in a courthouse, in a secure location, make sure there's no copying of it or no photography, maybe on a cell phone from it, and allow it to be disseminated in that instance. So I think everyone agrees everyone should have access to it. I think there's just a disagreement on what access should be provided to that litigant, particularly the fact that if they're given the report and they do disseminate it, they shall be found in contempt, but may or may not be having consequences with it. I think that's a big concern, and I can understand it. And one thing I think to myself is, well, why should an attorney then have a copy of the report in their office, but the pro se litigant wouldn't? And the only thing which I could see from a judge's perspective is that you can do more to an attorney. If this is the attorney's livelihood, and they're practicing, whether it be further discipline or further sanctionings, I think maybe they think that sometimes the attorneys will have further consequences and see what this occurs and may have more respect as what contempt of court is, where when you're dealing with a custody proceeding, the emotions often rules rather than rationalities. And some parents may say, I don't care what the judge is going to say at this point, I just need to go and get retribution no matter what. And I think that's just a concern which you may want to think about either amending or looking at this bill in the future. Just my concern.
Certainly, you raise an issue that actually the First Department, the Appellate Division of the First Department, in a decision commented on the violation of due process rights of parents and the different access treatment between a pro se parent who's a litigant, where the other side may have an attorney and have access to more information and have a copy of the report than the pro se litigant, who is at a disadvantage at times under current law by not having that access. And basically come to the conclusion that both parties should have similar access. Clearly we could provide and would, in an ideal situation, parents would be entitled to, who could not afford an attorney, who now are forced to go pro se, could be provided with counsel paid for, by the state, by the locality to proceed. But we're not at a point where we can do that, and unfortunately, so many parents, particularly family court, or so many of the litigants do appear pro se. We need to really level the playing field so that they are not at a disadvantage. They're already at a disadvantage by not having an attorney. We shouldn't have them at another disadvantage because they don't have an attorney and not have access to the information that's going to be making an important decision about their child.
Thank you. Mr. Speaker, on the bill.
On the bill, Mr. McDevitt.
I certainly agree with the sponsor. I think there are some many good things in this bill, particularly the fact that, listen, when a child custody proceeding is occurring, you have a very sensitive issue, and you want to make sure the child's completely protected. And certainly each side, each litigant, should have the right to see what the judge is going to see regarding the health of that child. But I think there are some concerns which have been brought up regarding the fact that if a person does willfully violate this order, certainly a person is going to be found in contempt. But I think there may be some more definitiveness as to that person should be punished or some sort of remedy concern to make sure that the child's protected. Once this information gets out, the information cannot be brought back. Once there's the language done, whether it's a family or friends, to undo that may be impossible. And I think both, again, the State Bar and the City Bar, I think bring in very good concerns that, again, I think they agree with the intent of the bill, but are just concerned that maybe additional safeguards be done to prevent even the possibility of these reports being disseminated to the rest of the world. So I will be actually voting in favor of this bill, but again, recommend the sponsor that maybe we look into further amendments and revisions on it to go and address all those concerns. Thank you.
Thank you, sir. Read the last section.
This act shall take effect on the 90th day.
Clerk will record the vote. running out the door. Look. If you were standing in the way, you'd have been cramped. Look, stamping. And we're get used to sitting because we're going to be some long days between here and the end of the session.
Really? Wow.
Not a look. Got to stay in place.
Job is never done.
Never, ever, ever. Just when you think you aren't, you are. Are there any other votes? Announce the results.
Ayes 101, noes 0.
The bill is passed. Mr. Morelli.
Yes, Mr. Speaker, I have 6 more bills here on the debate list, which we will take up next week. How about that? But I understand you have some housekeeping for the resolutions.
We're going to give you your own reality show, Mr. Morelli. We have some housekeeping. On a motion by Mr. Kavanaugh, page 12, calendar 150, bill number 3389A, amendments are received and adopted. On a motion by Ms. Glick, page 47, calendar number 559, 9689, amendments are received and adopted. On behalf of Ms. Rosenthal, bill number 7555, Assembly bill recalled from the Senate. Clerk will read the title of the bill.
An act to amend the tax law.
Motion to reconsider the vote by which the bill passed the House. Clerk will record the vote. Clerk will announce the results.
Ayes 134, noes 0.
The bill is before the House and the amendments are received and adopted.
We're going to have one more piece of housekeeping.
We have one more piece of housekeeping because it's never over.
We don't know the page, but
On behalf of Mr. Dendecker, calendar number 508, bill number 7231, remove the star.
amendments are received and
The amendments are received and adopted, not on that page. And we have a few resolutions, which we will take up in one vote. On the resolutions, all those in favor signify by saying aye. Opposed, no. The resolutions are adopted. Mr. Morelli.
Yes, thank you, Mr. Speaker. I now move that the Assembly stand adjourned until May 12th, tomorrow being a legislative day, and that we reconvene on Monday, May 16th at 2 p.m., Monday being a session day.
The Assembly stands adjourned.